The question is, how often in a week do you find that you attend court?
For me, I'm in court pretty much every day, unless I know that I have a particularly long case coming up, then I will book in a day to prepare that case. So it means it's less work over the weekends. So I find it now easier to manage my diary in that way. But ordinarily, I'm doing at least one, if not multiple cases per day.
Thank you, Prissy. Anyone else like to comment on the particular practice?
In my criminal and military law days, I was in court every day, quite often including Saturdays and bank holidays. But now doing primarily civil practice, and especially the sort of stuff I do, a lot of it's defamation. There is this thing that only 3% of issued claims make it to trial. So I am hardly ever in court these days. And I'll be perfectly frank with you, because of the way the cost regime works these days and the way judges are very much encouraged now to do active case management, to be perfectly frank, if you're in a trial, it's either sort of possible, it either means that it's at the stage, and I'm speaking to a judge recently about this, and he's saying sometimes there are some trials where it is literally just toss a coin. But if you're actually in trial, it means either it's so finely balanced it is almost toss a coin, or something has gone horribly wrong. Either somebody's being unreasonable or somebody's not seeing something. But yeah, in civil, I mean, obviously there are civil trials do exist, but we are so encouraged these days to do ADR and to sort things out before we get anywhere. And judges, especially nowadays, are much more willing to just strike out cases. Even if there's this technically inarguable case there's this what's called Jamil jurisdiction, where they can just say it's not worth it. Yes, technically there is a case here and there is an argument and there's a remedy, but it's just not worth the resources. You should, and judges will say that now, especially when it's just counsel and directions hearings. They will say, go outside, bang your clients' heads together, or I will find a way of penalising both sides in court.
Interesting. Anyone else want to contribute?
Pretty much. Sorry. I'm in court pretty much all the time, and now with CVP, which is a common video platform, you can end up doing cases in Leeds first thing in the morning. By 11 o'clock, you can be in London, somewhere else by 12 o'clock or 2 o'clock. So it's a whole new regime now in terms of being in court, but not physically. You could be at home.
As a solicitor advocate, because I take on the role of advocate as well as solicitor, so some days will be preparation, some days will be prison visits, will be police station attendances, paperwork, but my practice tends now to be mainly advocacy. So like Kadeem and any busy barrister, no matter what type of profession, we try and be in court as much as we can, because that's how we get paid, that's how the firm gets paid. If you're in a long trial, you're going to be in court every day, but you may still have, on top of your advocacy, you may still have all the other prep, and I think that's one of the things in terms of certainly criminal law. I'm sure it's the same for others, that your day doesn't start and finish with the court day. Lots of my friends say, well, you know, the Crown Court, you know, sits at 10 or 10:30 and finishes at 4 or 4:30. What an easy day. Well, by and large, Kadeem probably knows that we're at court, you know, by 9 o'clock, sometimes 8:30. We're finishing at 4:30. We're seeing the client till 5:30, and then we're working after hours when we get home, preparing, reviewing what's gone during the trial. And so they're long hours. And so the court work sometimes is actually a bit of a break. But I try and be in court most days if I can.
And don't forget, advocacy doesn't just happen in the courtroom. I mean, we are sort of discouraged from over litigating things in correspondence and heating up the temperature. It's all about try and settle this. But that doesn't mean to say that even in a very polite exchange, even if it's by telephone or email rather than a formal letter, you can still be making the points. Dear Bob, I'm sure we can get this together. We don't want this to go to trial because, yeah, I understand what your client's saying, but let's face it, we're going to be able to say this, this, and this, and the judge is probably going to say this. You know, you are constantly trying, because you know, you're trying to get the result from your client, and sometimes they will say, "I want my day in court," and we go, "No, you don't. No, you don't." I mean, I overuse a phrase a lot in regards to costs, because the BSB insist we are transparent on costs, and they said, "What's your cost information?" And mine on my website literally just says, it's a quote from Daniel Defoe: "I have been ruined but twice, once when I lost a lawsuit and once when I won one." And I point that out to people and say, you know, I can get you the piece of paper at the end of the day, but it won't have been worth it. You know, that's like saying, I don't want to sort of say we never go to trial and we never, you know, actually do courtroom work. But yeah, advocacy, it's a constant thing, because again, it's the art of persuasion. And if you could persuade your opponent to settle or throw the towel in or come to some sort of arrangement, then, you know, that's advocacy.